All right, well, welcome to the second day of what we're calling our coronavirus cancellations moot court competition. For those of you who did not participate in our live stream on Tuesday, let me introduce myself and then give you a little bit of explanation about what we're doing. My name is Cheryl Anderson. I'm a professor of law here at the law school, and I am the director of our moot court program. The members of the moot court board are going to be participating in a chat in conjunction with this, and I will let them introduce themselves when they come on, as well as they will give you an introduction to our judges for today. This is an event that we are doing because our students had been preparing to participate in their national moot court competitions, but unfortunately they were canceled as a result of the COVID-19 breakout. And so we wanted to give them an opportunity to present those arguments that they had been working so hard to prepare. We are going to do 2 rounds today. This is the first one involving our Gibbons criminal procedure competition. And you will be hearing 4 arguments. There will be 2 arguments for the petitioner and 2 arguments for the respondent. Each of those will last about 15 minutes. At the end, there will be a short rebuttal in which the petitioner is allowed to come back and respond to the arguments made by the respondent. We have 2 judges who, again, I indicated that the moot court folks will introduce to you, and they will be asking questions throughout the competition. What you will not see is that I will be acting as the bailiff, and I will be giving them time cards to allow them to count down. I will give them a 5-minute card, a 2-minute card, a 1-minute card, and then a stop sign. The way a moot court competition works is that we go through a number of these sorts of rounds, and then after 2 or 3 preliminary rounds, a decision is made about which teams will advance to what we call the elimination tournament, which runs a lot like you're familiar with, like the NCAA Sweet 16, for example, where you have to win your round and then you advance through a quarters and a semis, and then finally a champion team is named. We are going to name a champion team as well when we finish with these series of moot court arguments. So with all of that in mind, the next step is that I, as bailiff, will call the court to order formally, and then I will turn it over to the chief judge, who will ask the parties to begin. So, oyez, 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 all those having business before this honorable court draw near, and they shall be heard. The Honorable Judges Sarah Taylor with Chief Justice David Herndon presiding. God save the United States and this honorable court. Judge Herndon.
Thank you very much. So we have the state of Setonia along with law enforcement officers Henderson and Jordan as the petitioners. The respondent is Bradley Jackson. Counsel for the petitioner, you want to begin, please?
Mr. Chief Justice, Justices, may it please the court. My name is Chase Rich, and I, along with co-counsel Joshua Colanese, represent the petitioners, the state of Setonia, and officers Chip Henderson and Mia Jordan. At this time, we request that 2 minutes be reserved for rebuttal.
Sure.
Your Honors, during my co-counsel's time before the court, he will discuss why the 14th Circuit Court of Appeals erred in holding that the respondent was seized under the 4th Amendment, even though his freedom of movement was not terminated. During my time before the court, I will argue that the Supreme Court of Setonia incorrectly held that there was no reasonable suspicion for officers to stop the respondent's vehicle when the officer knew that the owner of the vehicle had a revoked driver's license. Accordingly, I will request that this court reverse the decision of the Supreme Court of Setonia, resulting in the denial of the respondent's motion to suppress. Your Honors, the Supreme Court of Setonia erred in its holding for 2 reasons. First, it is entirely reasonable for an officer to assume that the registered owner of a vehicle would be the one driving. Second, an overwhelming amount of legal authority has allowed this kind of stop to happen in some capacity. In Terry versus Ohio, this court held that a law enforcement officer may briefly stop and detain an individual without a warrant when that officer has an articulable and reasonable suspicion based in fact that the detained person is committing, has committed, or is about to commit a crime. In United States versus Arvizu, this court also noted it has purposely avoided creating a bright line rule regarding reasonable suspicion and that the reasonable suspicion standard is fluid. However, in that same case, this court held that reasonable suspicion standard is considerably less than proof of wrongdoing by a preponderance of the evidence.
Help me understand one thing, even if it's a sort of a lesser burden, as you argue, doesn't the suspicion go to the car, not the driver in this case? I mean, you have the car, but they don't know who's driving. Maybe it's this gentleman's or that gentleman's wife or brother or child. They don't have suspicion as to the particular driver of the car at that moment, do they?
Your Honor, as this court has held previously, reasonable suspicion allows an officer to use factual and practical considerations of everyday life. And it is a factual and practical consideration of everyday life that the owner of the vehicle would be the one driving it. While this is not always the case, it is still a common sense consideration that officers are allowed to consider in making this determination of reasonable suspicion. And as this court held in a case with facts that are materially indistinguishable from this case just 3 days ago in Kansas versus Glover, this court expressly approved of this kind of stop when an officer does not have information that would negate the owner as the driver. And as this court noted, the fact that the registered owner of the vehicle is not always the driver does not negate the reasonableness of an officer's assumption to stop a vehicle under these circumstances.
Shouldn't we at least require that they take a look at the driver and see if that additional evidence helps inform the suspicion?
No, Your Honor. In Kansas versus Glover, this court held that an officer does not need to take this extra step. If the officer has only the information that a registered owner of a vehicle, it has a revoked driver's license, and then that vehicle is being operated on a roadway, then that's all the information the officer needs to stop that vehicle. If the officer has any information that indicates that the owner of the vehicle is not the driver, such as an observation of the general description of the driver that would not match the description that the officer would know about that would be indicated in the state database, then if that officer has that additional information, then they do not have reasonable suspicion. However, given that officers are not always able to make these kinds of observations depending on road conditions, weather, or tinted windows on a car or helmets on somebody on a motorcycle, officers should not be forced to make these kind of observations, and we should defer to their training and reasonable judgment in making these considerations.
That wasn't the case here, though, correct? Is there anything in the record that indicates that any of those factors were at play here?
No, Your Honor. There are no factors indicated in the record regarding tinted windows. As stipulated on the record of page 3, all Deputy Ellison knew when he stopped the respondent's vehicle was that the registered owner of his pickup truck was Mr. Bradley Jackson, and that Mr. Bradley Jackson did not have a valid driver's license. And as this court noted, again, in Kansas versus Glover and in previous decisions, it is a common sense inference that the owner of a vehicle would be the driver. Again, the reasonable suspicion inquiry falls considerably short of 51% accuracy. So all there has to be is a suspicion. This is far less than probable cause standard, which Mr. Jackson is essentially arguing that this court have to stop him in these situations.
Doesn't this standard, if we apply what you're asking us to apply, doesn't this disproportionately affect low-income people who often have to share a vehicle? So they would be more likely to get more stopped more often than someone who is a family that's more affluent, where everyone has a car of their own?
No, Your Honor, that would not be the case, because while a family that may have to be forced to share a vehicle may get stopped that first or second time, it is still a reasonable suspicion the very first or possibly the second time that the owner of the vehicle would be the one driving it. And if afterwards officers knew that the family or friend of the registered owner of the driver was frequently the driver, then that would be information that would negate the officer's reasonable inference, and reasonable suspicion would no longer happen in those cases. And as the court in Kansas versus Glover noted, that empirical studies confirm what officers' common experience, which they are allowed to use in reasonable suspicion, reveals is that drivers with revoked license often continue to drive and pose safety risks to other motorists and pedestrians. And in that empirical study that this court recognized, that happens to be up to 75% of those with revoked driver's license that continue to drive without a license. And as reflected on page 2 of the record, the respondent in this case was charged as a habitual offender, meaning that this was his third or subsequent time driving on a revoked license. And again, just 2 days later, the respondent was seen driving on a revoked license when he had his encounter with petitioners Henderson and Jordan.
So should we require, as a matter of policy, that we take full advantage of technology, face recognition software, for example, to put more certainty, raise that bar a little bit, put more certainty into the inquiry?
No, Your Honor, because as this court has repeatedly reaffirmed in the past, all reasonable suspicion requires is that the officer simply have a suspicion. It is far less than the 51% preponderance of an evidence standard. So to require that bar, as you have suggested, Your Honor, would basically change this court's precedent on reasonable suspicion and no longer make it a reasonable suspicion. It would then push the reasonable suspicion standard closer to probable cause, which this court has frequently and repeatedly refused to do in the past. And Your Honors, this is unlike the suspicionless stops that the respondent contends that this is like in Delaware versus Prowse. In Prowse, the officer testified that his sole reason for stopping the defendant was to check the license and registration of the driver. However, that case was decided in 1979, long before in-car computers were installed in police vehicles. There, the officer had no reasonable suspicion whatsoever to stop the defendant and check his license. Here, Deputy Ellison had a suspicion. He knew that the owner of the respondent's vehicle had a revoked license. He knew that that vehicle was being driven on a Setonia public road, and as he likely knew, based off his practical consideration of everyday life, that owners of the vehicle are often the one driving it. Putting these facts together, he had a particular and reasonable basis for assuming that the respondent's vehicle was being operated illegally. Because of this, he had reasonable suspicion to stop the respondent and confirm the identity of the driver. And Your Honors, turning to my second point, the ability of law enforcement officers to conduct this briefing investigative stop has been upheld on an overwhelming amount of precedent. Most notably, just 3 days ago, this court allowed officers to make this kind of stop in Kansas versus Glover. It has also been routinely upheld in circuits and the states. For example, in United States versus Copland, the First Circuit found reasonable suspicion when the officer's computer indicated that the defendant did not have a valid driver's license. In United States versus Broca-Martinez, the Fifth Circuit found the reasonable suspicion whenever a computer check could not confirm the insurance status of a vehicle, which by itself does not reasonably suspect that someone was driving without an insurance, simply that the state does not have that confirmed information. Also, in United States versus Miranda-Sotolongo, the Seventh Circuit found reasonable suspicion when 2 state database checks could not find a vehicle's registration. Also, the Eighth Circuit in United States versus Stevens found reasonable suspicion to stop a vehicle whenever a database check showed that license plates were not on file. And similarly, the 10th Circuit found similar. Also, 10 state Supreme Courts have held that an officer may stop a vehicle when he or she only knows that the registered owner has a suspended license, unless that officer has information that suggests the owner is not driving, similar to what this court has upheld in Kansas v. Glover just 3 days ago.
Counsel, should this court consider the seriousness of the underlying offense? Like in this case, they were able to see that he was habitual driving without a license, but should we require maybe the officer to do more when the crime that is involved is lesser, the offense that involved is lesser?
Your Honor, I would like to answer your question in 2 parts. First, we should not require officers to make that additional step to identify a driver, because again, all this is reasonable suspicion to stop someone for a brief investigatory stop. And all that it requires is that an officer have a particularized and articulable basis, which the Deputy Ellison had in this case, where that somebody may be committing a crime. And second, Your Honor, to answer the second part of your question, we should I'm sorry, can you repeat the second part of your question, your question, Your Honor?
I think it was actually just kind of one question about whether the severity of the offense should play into this. Should it be kind of a sliding scale where if the offense is less serious, perhaps the officer has to do more to determine whether or not it's actually the same person that owns the vehicle that's driving it.
Okay, well, again, Your Honor, no, we shouldn't, because that would elevate the reasonable suspicion standard past what this court has routinely held it to be, such as in Terry versus Ohio, and in cases past that, such as Navarrete versus California and Illinois versus Wardlow. Because again, in those cases, the reasonable suspicion standard depends on the factual and practical considerations of everyday life, on which reasonable and prudent individuals act. Under those precedents, officers are permitted to make common sense judgments and inferences about human behavior, and we should not consider the severity of a crime in that, because again, it is still a crime, Your Honor. If an officer has reasonable suspicion that someone is speeding, which is a petty offense in most states, then the officer can stop that individual, even if it is just a petty offense. And in here, this case was actually a misdemeanor, which is a much more severe offense than just say a petty crime. Also, Your Honors, as I was mentioning earlier, not an additional 10 states intermediate appellate courts have held the same as those other 10 states. States on the East and West Coast, in the Midwest, and in the South allow for an officer to determine the identity of a driver of a vehicle that is owned by an unlicensed individual in these sorts of stops. This is not a novel police practice that should be suppressed. It is used across the country to help keep the roadways safe. And as this court stated in Krause, drivers without licenses are presumably less safe drivers whose propensities may well exhibit themselves. This is especially true when someone is suspected of driving on a revoked license, or a state sought fit to indefinitely take away the driving privileges of an individual. If the states see fit to revoke the driving privileges of a person, then it is presumably for compelling reason. We should defer to the judgment of the state and in the judgment of officers and the ability to make these very brief investigative stops that can help keep dangerous individuals off the roadways. Therefore, we respectfully ask that this court reverse the decision of the Supreme Court of Setonia. Thank you.
Thank you, counsel. We have the argument from second counsel, please, for the petition.
Chief Justice, Your Honor, and may it please the court. My name is Joshua Colonese, and along with my co-counsel Chase Rich, we represent the petitioners, officers Chip Henderson and Mia Jordan. In my time before the court, I will assert that the 14th Circuit incorrectly held that Jackson was seized when he was struck by a bullet because intentional infliction of physical force that results in escape only amounts to an unsuccessful attempt at a Fourth Amendment seizure. Your Honor, the Fourth Amendment protects the rights of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Furthermore, when seeking damages under 42 U.S.C. under 1983 for excessive force used in violation of the Fourth Amendment, the claimant must demonstrate a seizure occurred and that the seizure was unreasonable. Here, Your Honor, we have clear established law that dictates when a seizure has occurred. This court has held in Broward versus County of Inyo that a violation of the Fourth Amendment requires an intentional acquisition of physical control over the suspect. Furthermore,
so the officer certainly intended to seize this gentleman, right?
Correct, Your Honor. However, this court asserts this point in Brendelin versus California, finding that a seizure occurs only when that suspect actually submits voluntarily or otherwise to the police officer's assertion of force or authority. Your Honor, as petitioner may argue, there is another confusing yet challenging rule for this Fourth Amendment seizure, and that is in Hadari D. And in Hadari D, it states that touch alone on behalf of a police officer without capture is enough to constitute a seizure. But Your Honor, from the time of the founding to the present, the word seizure has meant a taking of possession, according to Webster's American Dictionary. To further this understanding, Black Law's Dictionary states and defines a seizure as the act or instance of taking possession of a person or property by legal right or process.
So the officers shot this car up, and in the course of it, happened to hit the person as well. Once they started shooting that car, their intent was clear. In the ordinary circumstance, the driver of the car would stop, completing the seizure. And don't we have that situation here? We just have a person that kept trying to escape.
Your Honor, the situation here does not show that there's a Fourth Amendment seizure for the reason that there was no capture. And that is evidenced in the fact that Mr. Jackson was able to escape police officers and then drive himself 60 miles to Brooke Hospital. It wasn't actually until the very next day in which police officers came to the hospital and apprehended him that he was there seized.
But isn't what you're asking us to hold, it's actually kind of sanctioning officers to use more excessive force. More excessive force in this case wouldn't have been able to run away if they had shot him more, for example. And is that really a policy that we want to take on?
Do we want them to kill him, for example? Then it'd be pretty easy to get a hold of him. But that seems like a drastic change in policy, right?
Your Honor, the point was not to kill Mr. Jackson. However, there are cases that mention that killing someone is definitely a seizure because there's a cessation of movement. However, here they were simply trying to stop Mr. Jackson from perhaps hurting the police officers, officers Mia Jordan and Chip Henderson, or perhaps hurting someone else, Your Honor. At the record on page 4, it is evidence that Mr. Jackson, it was reasonable for the police officers to come to Mr. Jackson and draw their weapons when Mr. Jackson began to flee in his vehicle, running over landscape, hitting another vehicle, as it's mentioned later in the record, and even stealing another person's vehicle whose car was left running. Your Honor, at this point, this individual, Bradley Jackson, is driving a heavy machine, a weapon, so to speak, in this truck. It could be reasonable that he could have turned his wheel towards the police officers and struck them. And it was at that point, Your Honor, when the vehicle did move forward that the police officers did draw their weapons and shot 13 times. And it was these 13 shots, Your Honor, each one individually trying to stop Mr. Bradley Jackson, which he did not.
So he was just standing in this parking lot talking to another guy, and somebody jumps out and starts pointing a gun at him. Why was it reasonable to even try to stop this man or seize him?
Your Honor, when Chip Henderson and officers Mia Jordan arrived to the complex, they were arriving on the suspicion and that there was a drug ring taking place at this complex, at this apartment complex. And it was upon seeing Mr. Jackson in his vehicle outside of the apartment that they asked him to show him his hands. It was at that point that Mr. Jackson fled in his vehicle and decided to escape the police officers, Your Honor. Your Honor,
what facts in the record indicated that there was evidence, or that there was something sufficient that the officers could believe that a drug deal was going on in this conversation that Mr. Jackson was having with the other individual?
Your Honor, there's nothing in the record that suggests that Mr. Jackson was suspected of any crime at that point. However, it was bad timing for Mr. Bradley Jackson. And Your Honor, that's not to say that Mr. Bradley Jackson is without remedy. Perhaps he could settle this in a tort claim, perhaps for a battery in civil court, where he could make a claim for medical damages and receive some compensatory damages. However, Your Honor, it just does not speak to the Fourth Amendment seizure, let alone a 1983 claim, which requires a seizure to take place, 1, and 2, for it to be unreasonable. Here it was reasonable, Your Honor, that the police did act in accordance with their duty and what has been permitted for them to act within the scope of their duty according to the law. Here, Your Honor.
When you talk about this guy being compensated, clearly the force used by the police officers is in question, whether it's reasonable or not under the circumstances, particularly this set of facts.
Yes, Your Honor. The force was used against Mr. Jackson, Your Honor, and that's not to say that the 2 shots that hit Mr. Jackson wasn't damaging to him, Your Honor. However, we really need to allow police officers who are trained to use their discretion to exercise that force when needed. And here, Your Honor, they were coming upon a hostile environment where it was known that there was a drug ring present. As I mentioned, they shouted to Mr. Jackson, and it was at that point when the totality of the circumstances turned towards an apprehension of physical harm. Furthermore, Your Honor, Respondent Bradley Jackson pled guilty to assault on a police officer and fleeing, which evidences the fact that there was some sort of apprehension of harmful or imminent contact, Your Honor.
So he entered a no contest plea, I think, right?
Correct.
And what in the record suggests that this was a known location for drugs? It strikes me that there might have been a suspicion of drug activity or a person involved in drug activity, but what's that got to do with two guys who aren't identified as that person out in the parking lot?
Your Honor, there's nothing in the record that states why there was why the police officers had that suspicion. However, it does mention that there was a drug ring taking place there. And to speak to that, Your Honor, we have to look towards the reasonableness aspect of a 1983 claim. The fact that they did not know that Mr. Jackson was not involved has nothing to do or play in this realm. It was a reasonableness aspect that he came to this apartment complex knowing that there was some sort of criminal activity going on. And as I mentioned earlier, Mr. Jackson, it was bad timing for Mr. Jackson to be there at the location. And to say that
timing is not a crime, right? So the officers drive up, they see these two guys, and they see the guys break up as they get there, and they're leaving or trying to leave, and they decide that they need to seize the driver of this car. How is it that they had reasonable suspicion to even think about stopping that car?
Your Honor, it was the very fact that they came up to Mr. Jackson asking him to show him his hands. That's where the totality of the circumstance comes in. At that point, Mr. Jackson could have easily
Does the record
ascertained.
reflect that they identify themselves as police officers? They're in an unmarked car. They're not in uniform. If they want somebody to know they're the police, they have to announce it. They have to announce it loud enough that the person can hear. I don't recall the record reflects that all that was clear.
It was not clear, Your Honor. They were in an unmarked vehicle and they were wearing tactical vests that were unmarked. And they did come up to Mr. Jackson asking him to show him his hands. However, Your Honor, at that point, it was a set of circumstances, Your Honor, where really it was one thing led to the other, which was essentially not in Mr. Jackson's favor, where at the point where the police officers did approach him and he left, that was the instant where the totality of the circumstance and reasonableness came in. So
what happens if you have 100 people living in that apartment building along with the person they were suspicious about? And to use your term, a matter of bad timing, 90 of them come out of the apartment building all at once because they're headed to some particular event that they all want to attend. Is it okay for the officers just to start rounding all those folks up and put them in cuffs, put them in some vehicle, put them in some place in the apartment building till they can talk to them all? Is that reasonable?
Your Honor, it'd be reasonable for officers to conduct perhaps some questioning, very non-invasive. But in this situation, Your Honor, it was at the point where Mr. Bradley Jackson decided to flee in his vehicle when the police asked him to show him his hands that really started this movement of reasonable defense, Your Honor. It was reasonable for these police officers to believe that they were in harm's way. With a bunch of
just as reasonable for Jackson to believe that he was about to be carjacked and needed to get out of there for his own safety?
Your Honor, we're not saying that Mr. Jackson did not have fear or did not feel as though that he did not feel that it's possible that him feeling that he was going to be carjacked would allow him to escape, Your Honor. But arguing the rule here, we're looking towards a reasonableness aspect that needs to be satisfied and a Fourth Amendment seizure that needs to be satisfied. So to one, Your Honor, the fact that Mr. Jackson did not stop and continued evading police officer negates the requirement for a Fourth Amendment seizure. And second of all, Your Honor, the reasonableness aspect, the police officers did believe that they were going to be harmed and acted within their accordance, Your Honor. They are trained police officers. They shot at the vehicle, trying to stop Mr. Jackson. Going back to the remedy, Your Honor, Mr. Jackson is not without remedy. Perhaps, again, as I mentioned, he can get a tort claim to stop future issues of the sort and put him back into the place he would have been had this not occurred, Your Honor. In sum, Your Honor, despite being struck by the 2 bullets, petitioner was not seized by officers Henderson and Jordan for purposes of the Fourth Amendment. Under longstanding case law from this court, a shot does not constitute a seizure without capture. Here, Your Honor, the officers used force but failed to effectuate an immediate seizure of the petitioner. As such, the 14th Circuit improperly found that officers' actions constituted a seizure. Therefore, Your Honor, we ask that this court reverse and remand the ruling of the 14th Circuit, because to do otherwise would ignore the proper established law in Broward versus Inyo. Thank you.
Thank you, counsel. So let's turn now to the respondent's argument. First up for the respondent, I think, Chase, you're up. Is that right?
Yes, Your Honor. Mr. Chief Justice, Justices, may it please the court. My name is Chase Rich, and I, along with co-counsel Antonella Santi, represent the respondent, Bradley Jackson. During my co-counsel's time before the court, she will discuss why the 14th Circuit Court of Appeals was correct in holding that Mr. Jackson was seized improperly under the Fourth Amendment when he was shot twice by petitioners Henderson and Jordan. During my time before the court, I will argue that the Supreme Court of Setonia was correct in holding that there was no reasonable suspicion for officers to stop Jackson's vehicle when the officer did not know the identity of the driver. Accordingly, I will request that this court affirm the decision of the Supreme Court of Setonia, resulting in the granting of Mr. Jackson's motion to suppress. Your Honors, the Supreme Court of Setonia was correct in its holding for 2 reasons. First, the Fourth Amendment requires that officers make inferences drawn from articulable and particularized facts to create reasonable suspicion, and not simply rely on assumptions. Second, this court should overrule Kansas versus Glover because it has incorrectly applied this court's Fourth Amendment jurisprudence regarding reasonable suspicion. Time after time, this court has held that the touchstone of the Fourth Amendment is reasonableness. As recently restated in Riley versus California, this generally requires that a law enforcement officer either have a warrant issued by a judiciary or reasonably rely on a specific exception to the warrant requirement. At issue here is whether the officer had reasonable suspicion to stop Mr. Jackson as required by this court in Terry versus Ohio. In Terry, this court held that a law enforcement officer may briefly stop and detain an individual without a warrant when that officer has an articulable and reasonable suspicion based in fact that the detained person is committing, has committed, or is about to commit a crime. Thus, reasonable suspicion requires that an officer be able to point to specific and articulable facts, which taken together with rational inferences from those facts, reasonably warrant that intrusion. Therefore, reasonable suspicion arises when these facts are put together to form an inference, which is an educated guess. An assumption alone simply does not rise to the standard of reasonable suspicion. And this court has routinely rejected the ability of officers to make stops based on mere hunches, which are basically assumptions.
Counsel.
This guy jumps in his car. I'm sorry. Go ahead, Judd.
Oh, I was just going to say, so facts, the officer in this case had the fact that this vehicle was owned by an individual whose license was revoked. Why is that not based in facts sufficient enough to support the stop here?
It does not meet reasonable suspicion in this case, Your Honor, because Deputy Ellison did not know who the identity of the vehicle was. There's no information reflected regarding he was familiar with the respondent's vehicle or that he was familiar with his driving habits. And second, Your Honor, as is reflected on the record, it is not a crime for someone with a revoked driver's license to own a car, because anybody can in fact operate that car as long as it is not the individual with a revoked license. So the mere fact that a vehicle was owned by someone with a revoked driver's license is not a crime. Therefore, that fact alone cannot lead to reasonable suspicion that a crime is being committed.
So isn't it a problem for Jackson that he disobeyed the order of the police officer, proceeds to get in the car, and now is driving a dangerous instrument capable of killing both officers? Doesn't that create a reason for them to seize this this guy?
Your Honor, that is regarding the reasonableness and the seizure that occurred 2 days after this incident. This incident occurred 2 days before, on April 28th, 2016, where he was simply stopped for suspicion of driving with a revoked license.
What about the counsel? What about the fact that he already had a conviction for being a habitual offender for driving without a license? I mean, doesn't that increase the factual basis for this officer's stop, knowing that the previous, that the owner of the vehicle has this past history?
Your Honor, it does not, because in one, it's not reflected in the record whether Deputy Ellison knew of these past convictions for driving with a revoked license. And second, just because someone has committed a crime in the past does not mean that they are more likely to keep committing crimes in the future. While the petitioner mentioned an empirical study about 75% of individuals possibly reoffending, there's still 25%. That's 1 in 4 people that do not reoffend. So we cannot just assume that because Mr. Jackson has had these violations in the past, that he's likely to keep committing them in the future.
But isn't that the entire purpose of the habitual offender statutes? Or laws, they get more of a penalty because the assumption is they've done it again, they're going to keep doing it.
Your Honor, in the habitual offender statutes, they are punished not because of their possible future violations, it's because of their past violations, and that after a while, those violations have accumulated into this habitual offender statute. The purpose of those statutes is not the punishment of future behavior, it's the deterrence of that behavior in the future. And as this court has rejected in case after case, assumptions or mere hunches alone do not create reasonable suspicion. In United States versus Bernani-Ponce, this court rejected the notion that police officers can stop a vehicle based on the assumption that occupants may not be U.S. citizens. Again, in Delaware versus Prowse, this court rejected the ability of officers to perform spot checks on vehicles to check license and registration. In both of those cases, officers assumed that there might be something illegal happening, but they had no reasonable and articulable facts they could draw an inference from.
But the cases involving immigrants, like the suspicion of them being illegal, those were based on assumptions made about those folks' race, correct?
Yes, Your Honor.
So isn't that different than an assumption made based on the owner of a vehicle having a prior offense? How are those the same or analogous?
They're analogous because both are assumptions about a certain class of individuals. In the case of Bernani-Ponce, the officer assumed because of the class of the occupants of that car being of apparent Mexican descent that they might be in the country illegally. Here, Deputy Ellison assumed based on the class of person that Mr. Jackson is that he has a revoked driver's license, that he is committing some sort of crime.
What class is that? I'm having a hard time understanding your argument. What class was Mr. Jackson?
The class that Mr. Jackson is in is, while it's not an expressly denoted class in statute, it is a class of people who have committed a crime in the past, which they are still protected under certain anti-discrimination laws. However, the Supreme Court of Kansas has rejected the ability of officers to assume such criminal activity in State versus Glover before it was decided on cert by this court. With facts that are analogous to this case, that court noted that an assumption has no basis in proof or demonstration, so it is only an inarticulate hunch or an unparticularized suspicion. But an inference, on the other hand, is based on an evidentiary premise, and thus it fits inside the standard of reasonable suspicion that was established in Terry. In this case, it is conceded on the record that Deputy Ellison, and that's on page 2 of the record, page 3 of the record, Your Honor, that Deputy Ellison acted on an assumption alone and with no other fact. In United States versus Cortez, this court described the process of finding particularized suspicion as an officer drawing inferences and making deductions from the data that they have. In this case, Deputy Ellison had no data whatsoever about who the individual driving the car was. All he knew was that the respondent legally owned and registered the vehicle, which again is not a crime.
So counsel, in this case, what more should Deputy Ellison have done to identify this individual before he initiated the stop?
Your Honor, if Deputy Ellison had made any observation that would corroborate his assumption and turn it into an inference, that would have been enough. Several states have held that that is enough if an officer is able to say make an observation that would match the description of the suspect that the officer has in mind, such as the general height, weight, sex of the driver. However, Deputy Ellison made no additional effort to make that observation in this case, even though he could have. As reflected on page 3 of the record, the stop occurred at 7:40 in the morning in a commercial area that has multiple lanes of traffic in either direction. Therefore, it is quite possible that Deputy Ellison could have safely pulled alongside the respondent's vehicle and had enough light to view into the cab of his truck to make such a general observation that could have corroborated his suspicion.
So what if it had been nighttime on a single lane road? Would that have been different? Would he have been required to do a lesser amount of investigation before he initiated the stop?
While some courts have held that in the past, Your Honor, we would suggest that Deputy Ellison would have to then have a different basis for establishing reasonable suspicion, such as an observation that of any number of traffic infractions that the respondent could have committed. But as reflected in the record, he wasn't even committing a single traffic infraction whenever he was stopped. So there can be no presumption that the respondent is an unsafe driver, because as clearly reflected in the record, he wasn't committing a single traffic infraction.
Are there cases that support that argument? The argument that if it's nighttime or they can't drive up and look at the vehicle and look into the vehicle, that the officer should observe some kind of traffic violation, a separate one?
Your Honor, I do not have a specific case in mind, but I do know that this court did hold 3 days ago in Kansas versus Glover that an officer can make this kind of stop whenever they don't have any information that negates the inference of the driver. However, in my second point, which I'm going to argue now, that this court should overrule Glover because it incorrectly applied this court's Fourth Amendment jurisprudence. It does this by impermissibly flipping the burden of proof. In Glover, the decision allows police officers to make this kind of stop whenever they lack information that negates their assumption. However, the state should instead bear the burden of supplying information that links an officer's assumption to a fact that would create reasonable suspicion. Glover instead allows officers to stop their inquiry into a matter once their initial assumption has formed. If they cannot make a stop after learning more information, why would any officer take the time to try to find information that would not allow this kind of stop? It essentially abrogates the duty of officers to make any further reasonable observations, such as the general description of the driver, as was possible in this case. Again, as was reflected on page 3 of the record, this stop occurred on a road with multiple lanes of traffic in either direction at 7:40 in the morning. Therefore, it is quite possible that the deputy would have had enough light and room to pull safely alongside Mr. Jackson to attempt to identify him. However, by flipping the burden, Kansas versus Glover has allowed officers to shirk these basic procedures and allow them to stop people who could be committing no crime at all and simply happen to be legally driving a vehicle that is owned by an inconvenient person to that innocent driver. Allowing officers to make this kind of stop without any reasonable suspicion would allow any law-abiding citizen who just happens to be driving a vehicle owned by a person with a revoked license to have their liberty interest intruded on by officers for nothing more than an assumption, which is essentially a mere hunch, which this court has routinely rejected the ability of officers to do in the past. And it is because of these reasons, Your Honor, that we respectfully request that the ruling of the Supreme Court of Setonia be affirmed. Thank you.
Thank you, counsel. Could we have other counsel for the respondent, please? And since I lost my place before, why don't you just answer the question that I asked of your co-counsel?
Sorry, Your Honor.
Never mind, go ahead.
Thank you, Chief Justice, Justices, and may it please the court. I am Antonella Santi, and I too represent the respondent, Bradley Jackson. In my time before the court, I will assert that the decision of the 14th Circuit should be affirmed because under the Fourth Amendment, two prongs must be met under Hadari D to establish that Jackson was seized. First, sufficient physical force was established when Jackson was shot twice. And second, there is clear evidence that officers Henderson and Jordan intended to seize Jackson when they both instructed him to stop and fired 13 bullets at him. Your Honors, as petitioner mentioned, this case presents a 1983 claim for use of excessive force in violation of the Fourth Amendment. And specifically at issue here is whether a Fourth Amendment seizure occurred. Now, this court has defined what constitutes a seizure in two distinct leading cases, and the most recent interpretation is set out in California versus Hadari D, where this court defined a seizure to occur by either one, a laying on of hands or application of physical force with the intent to restrain, even if ultimately unsuccessful, or two, by the submission to the assertion of authority. Now, the factual scenario in the present case fits squarely within the first prong under the Hadari D standard, so it is our position that this court apply Hadari D in making its determination. Your Honor,
What about the Brower case? How should we interpret that case? Those are both by Justice Scalia, correct? But they seem to hold different things. One, the Brower case seems to hold that mere force can be a seizure, even if even if the suspect escapes. So how do we reconcile those two cases?
Your Honor, Justice Scalia did decide both Brower and Hadari D, but we also should consider that Hadari D was decided 3 years after Brower, and Hadari D did not overturn Brower. In fact, the second prong under Hadari D that I mentioned, the other way a seizure can occur by the submission to the assertion of authority, is the Brower definition, which requires assertion of authority and the cessation of movement. What Hadari D did was add the first prong, which allowed the application of physical force through the means of some form of instrumentality or by the officer's hands to constitute a seizure if it was applied with the intent to restrain, even if it was ultimately unsuccessful. And the reason Justice Scalia did that in Hadari D was to avoid the use of excessive force, Your Honors, which is the case here, where officers Henderson and Jordan fired 13 bullets. And now their position is that a seizure didn't occur because capture wasn't successful, Your Honors. And this is exactly what Hadari D meant to avoid.
What if the bullets hadn't actually hit Mr. Jackson? What if they had just hit the vehicle and not actually injured him? And he had then subsequently escaped? How would that affect the case? Would that be different?
Yes, Your Honor. Under Hadari D, there does need to be some sort of contact with the person of the suspect. Now, there have been circuits that have deemed a police officer slamming into a suspect or slamming a vehicle into a suspect, that circuits have reasoned that constitutes physical force for a Fourth Amendment seizure. However, there does need to be some form of contact. So the bullets just striking the vehicle wouldn't have been enough in this case. However,
so if they stopped the car and killed the car and Jackson got out and fled, would there have been a seizure?
No, Your Honor, because under petitioners, if the seizure would have been if the suspect had been injured, specifically under the Hadari D definition, Your Honors. To my first point, the bullets that hit Jackson's arm and lower back are sufficient to establish the element of physical force required under Hadari D. And numerous circuits have applied the Hadari D reasoning. And with respect to the physical force applied through the means of a gun, the circuits have reasoned a bullet that strikes the suspect is the physical force required for a Fourth Amendment seizure. For example, the Fifth Circuit in Lytle versus Bexar County, there the court reasoned that the bullet that struck a passenger in a vehicle constituted a Fourth Amendment seizure. The Eighth Circuit and Moore versus Indahar concluded that a bullet striking the suspect during a pursuit constituted a seizure. The 11th Circuit in Carr versus Tatangelo reasoned that the bullet striking the suspect in the abdomen while in pursuit constituted a seizure. Also, again, in the 11th Circuit in Vaughn versus Cox, the court reasoned that the suspect being struck in the spine constituted physical force required for a Fourth Amendment seizure. The
Do
third.
any of these cases involve an individual who escapes and is basically free for so long before finally being apprehended? And does that make a difference? How much time he was able to get away? He went to the hospital, all that kind of stuff. Quite a bit of time passed. Does that matter? And do any of these cases address that?
Yes, Your Honor. And all these circuits I just mentioned, all of those suspects fled, and those circuits applied the Hadari D reasoning that regardless of escape, it still constituted a Fourth Amendment seizure. There is no specific case that specifically speaks to the length of time that would result in not constituting it a Fourth Amendment seizure. However, Hadari D does use the word temporarily evades capture, and perhaps in this case, it is applicable because Jackson temporarily evaded capture. He was apprehended at the hospital the next day. So it's not like Jackson fled for a number of years or he got on a plane and left. He was apprehended the next day. And after he was shot, he didn't went on to complete any crimes or hurt anybody else. He drove himself to a hospital, Your Honors, to receive medical assistance for the injuries he had sustained during the shooting, Your Honors. And here, petitioner attempts to narrow the scope of what a Fourth Amendment seizure entails and incorrectly defines a seizure to require acquisition of physical control. However, this is not a requirement that this court and other circuits have adopted to establish a seizure. The district court's decision, as well as the circuits requiring a submission of authority as the sole requirement of a seizure, promotes a narrow standard permitting law enforcement officers to shoot a suspect without ramifications. Your Honors, earlier, Your Honor mentioned to petitioner, do we want law enforcement to kill suspects for it to constitute a seizure? And Your Honors, the answer to that is no. And that's exactly what Hadari D meant to avoid, the use of excessive force and not allowing law enforcement to escape liability in situations where they do in fact injure a suspect, but are not able to successfully capture the suspect at that very moment. Your Honor, and to my second point, there is clear evidence that officers Henderson and Jordan intended to seize Jackson when they both instructed him to stop and fired 13 bullets at him. The circuits I mentioned earlier, including the 1st, 3rd, 5th, 8th, and 11th circuits, have all interpreted a Fourth Amendment seizure to occur when a suspect is shot by a law enforcement officer with the intent to restrain the suspect, Your Honors. And in this case, the intent element has been established as reflected on page 4 of the record. The officers instructed him to stop and also instructed him to get out of the car. The officers then proceeded to fire 13 bullets at him. This evidences the intent required for a Fourth Amendment seizure under the Hadari D standard. Now, Your Honors, another key point to keep in mind here is this was a residential area, and officers Henderson and Jordan began to shoot 13 bullets, and not being aware of the surroundings that perhaps a child could have walked by, another adult, and that there they did not use their reasonable discretion in using the type of force that they applied. In this case, the petitioners could have refrained from shooting after the first failed attempt at stopping Jackson's vehicle. Petitioner mentioned that the officers Henderson and Jordan felt that they were in harm's way. But as reflected on page 4 of the record, Officer Jordan was standing to the front side of the driver's tire, next to the driver's side tire, and Officers Henderson was standing next to the driver window. They were in no way in front of harm's way, Your Honors. So
there's no conceivable way that they could have been injured, even given their particular location.
Your Honor, do you mean the residential area, or just where
No,
they
I'm talking
were
about
standing?
the officers right by the car, as the defendant is, or the suspect is pulling away. Even though they're on the side, a tire can come in contact with the body of the officer. They don't have to be right in front of the car, do they?
Your Honor, and that's a fair point to make. Jackson could have turned the other way and struck the officer that was standing next to the tire. However, what would have sufficed is maybe once or 2 shots that they could have fired to prevent that from happening. However, the second bullet that struck Jackson was to his lower back. That means that Jackson had already driven out of the complex and had his backs to the officers. So the officers there were not in harm's way, and they continued shooting instead of pursuing Jackson in their vehicle. And as petitioner mentioned, they were trying to prevent Jackson from harming others. If that was the intent, they should have gotten in their car and pursued Jackson. Jackson was not apprehended till the next day at the hospital. That means the officers didn't even make an attempt to quote unquote prevent Jackson from harming other individuals on his way to the strip mall after escaping. And Your Honors, as reflected on page 4 of the record, Jackson reasonably feared for his life. He did not know the individuals walking up to him were law enforcement officers. He did not hear the officers tell him to show his hands and to get out of the car. The officers did not say that they were law enforcement officers. So Jackson reasonably believed he was being carjacked, and also reflected on page 4 of the record. He asked passerbys on the street to contact the police because he reasonably thought.
How do these facts that you're telling us right now pertain to whether or not he was seized?
Your Honor, I'm just trying to make light of the fact that Jackson reasonably feared for his life. He did not know the law enforcement officers were trying to catch his attention, and he reasonably feared for his life. That's why he escaped. He was not escaping to harm anyone or to commit any further crimes, Your Honor. And the application of physical force used here is sufficient to constitute a Fourth Amendment seizure as required under Hadari D, Your Honors. There was 2 bullets that struck him, and the intent to seize was there. The petitioner concedes that each of the 13 bullets were meant to stop Jackson. So this means if each bullet had struck Jackson and he still managed to escape, Officer Henderson and Jordan would not be liable under the Brower standard. Your Honors, this would open the doors to excessive use of force on behalf of law enforcement officers on the justification that capture was not successful, Your Honors. And contrary to petitioner's contention that immediate cessation of movement is required, this court holds that for a Fourth Amendment seizure, if the law enforcement officer applies intentional physical force in a manner to control the pursued suspect's ability to evade capture, submission to authority and cessation of movement is irrelevant. And it is for these reasons, Your Honors, this court should affirm the 14th Circuit's ruling, because Officers Henderson and Jordan seized Jackson by shooting him not once, but twice. If this court were to rule in favor of Officer Henderson and Jordan, it would not only ignore this court's established precedent, it would also promote a shoot first, think later mentality that this court sought to avoid under Hadari D. Thank you.
Thanks, counsel. Petitioner, care to rebut?
Yes, Your Honor. Just a few quick points on rebuttal. First, regarding the reasonable suspicion issue, contrary to what the respondent has suggested, Glover did not incorrectly apply Fourth Amendment jurisprudence. It is simply reaffirmed that common sense is a key in forming what has been termed simply a suspicion of a crime being committed, not probable cause. And second, regarding the seizure issue, just to clarify what my co-counsel said about suspected drug activity in the record, in the area, on page 4 of the record, it states officers were at the complex to execute an arrest warrant on a separate individual for involvement in organized crime and drug trafficking. And Mr. Jackson happened to be in front of that individual's apartment when officers arrived, and then Jackson fled. And also to the seizure issue, this was not a seizure even under the alleged expansion of Brower in Hodari D. While Hodari suggests that a seizure occurs when someone is restrained briefly, which even for a moment, in this case, respondent was not restrained even for a moment. After being hit, he continued to drive away, steal a car to avoid contact with the police, and drive another 60 miles.
Counsel, do you have an answer for my question that I asked about excessive force and how what you're asking us to rule would not encourage excessive force by officers?
Your Honor, this would not encourage excessive force from officers because, one, this court, the question of whether the shots were reasonable is not a question that is before this court. This court is expressly answering the question of whether if someone who has been shot but is not restrained has been seized under the Fourth Amendment. And under these facts, in a totality of the circumstances, the respondent was not seized because he was not stopped even for a moment, because again, he drove away, stole another car, and then drove 60 more miles. So under the Fourth Amendment, he was not seized. And therefore, we respectfully ask that this court reverse the decisions of both the Supreme Court of Setonia and the 14th Circuit Court of Appeals. Thank you.
Thanks, counsel. We'll take the matter under advisement.
All right, thank you very much to the advocates and the judges. And at this point, I'm going to end the live stream on YouTube.